cases where they were bringing individuals to account for doing nothing other than encouraging others to commit crimes. So crimes of incitement to genocide or instigating crimes against humanity. There are not many of these trials in the whole scheme of things. If one looks at Nuremberg and the Yugoslav Tribunal and the Rwanda Tribunal and the ICC, it's only about 10% of cases. But I was very intrigued by about 30 cases that I looked into in some detail. And I first of all just dug back into kind of the history of Western law, and I found that there's really been a long-standing principle which one can find in Aristotle's Rhetoric, which, by the way, is a great book, which I recommend you take a look at because it's incredibly relevant today. And Aristotle records the view in ancient Greece that even there, the individual who instigated others, who planned the event, who encouraged others to do it, would be considered more guilty than the doer. Because they're the intellectual author of the act. So if we go back, 2,500 years, we can find these ideas very well established. And I've included some photos here of individuals who were convicted at international tribunals. So you can see in the bottom right-hand corner, Julius Streicher, who's a Nazi propagandist who was convicted and hanged at Nuremberg. Radovan Karadzic, who is convicted of amongst other things, he's convicted of commission of genocide, ordering genocide, but also disseminating propaganda. And then in the top right corner is actually a play called Hate Radio, Radio Hate. I can't remember which way around it is, but it's a German play, and those are actors representing Ferdinand Nahimana and Georges Ruggiero, who are both convicted of incitement to genocide in Rwanda. So we do have this long-standing tradition in Western law, and we have a number of convictions of individuals for the speech acts that they made inciting others to commit crimes against humanity and genocide. However, these cases are the exception rather than the rule, and there are a lot of acquittals. There are many, many more acquittals than there are convictions. So even going back to Nuremberg, Hans Fritsch is acquitted. He was deputy minister of propaganda under Goebbels. And you see a number of other individuals who were acquitted at the ICC, or Bizimungu, who is in the bottom middle photograph, who is acquitted of incitement to genocide. He was the Minister of Defense in Rwanda at the time of the genocide. And then in the top right corner, Vojislav Šešelj is acquitted, although he's later convicted on appeal. And then Kaliste Barushimana, who is from the DRC, who is acquitted of all crimes of instigating others. So I found that actually the acquittal rate was about 55% in these trials. So more individuals are getting acquitted. And it begs the question, why? Because the acquittal rate is very low for war crimes. It's only about 5% of individuals brought before international tribunals are acquitted of war crimes. But for speech crimes, the acquittal rate is much, much higher. So what's going on there? That was my initial problem. What I found was that there was a problem of causation, that even though some speech crimes are what are called inchoate crimes, which means they don't have to actually happen to be for the individual to be convicted. So attempt is an inchoate crime, conspiracy is an inchoate crime, and solicitation in US law. Those are the three inchoate crimes. And they don't actually have to transpire or be executed for the individual to be convicted. But courts in international tribunals are looking for some evidence of causation, even though they don't have to. They are. So there are two inchoate crimes: hate speech as persecution and incitement to genocide. And then there are other crimes which are modes of liability, where the individual, for instance, instigates crimes against humanity. This is the one really technical law piece, which is all in the book. So with the modes of liability, causation is essential. With the inchoate crimes, it's not. But courts are treating them all the same. They're generalizing, and they're looking for evidence of mental causation. And I asked a judge at the ICTY, what evidence would you look for to demonstrate that an individual is guilty of a speech crime, such as hate speech as a form of persecution? And he replied, I plant in the mind the not yet existing intention that the crime be committed. So here they're looking for evidence that the speaker plants in the mind of the listener the intention which doesn't yet exist, that there be a crime. I asked a group of prosecutors what was the ideal evidence that they could bring to show this mental causation. And they replied, the testimony of an insider, that I was following a leader, that I heard his words and I would die for him and do anything he says. And also that he was an authority figure who commanded my behavior. I heard his words and then I acted. So this kind of mental causation is very hard to prove. It's also very hard to get this kind of evidence from insiders. One of the difficulties of international tribunals is that they can't, as in organized crime cases, say in the US, work up through the chain of command to get to the very top. They have to just indict the individuals who are most likely to be the perpetrators of grave crimes, that is, the most senior individuals. And so they can't work up that chain of command and get those insiders to turn against them. So I think it's very hard to prove causation. And I'll just indicate here that we may think of these international tribunals as being very powerful. They're international, they're set up by the UN, but actually they're quite fragile in many ways. Perpetrator testimony in these cases seldom holds. There can be intimidation and bribery. We saw that in the Rudo Sang case at the International Criminal Court, where all of the insiders who were willing to testify that William Rudo encouraged them to commit acts of violence, they all dropped out of the trial. In Nahimana, which is a Rwanda case, that was the media trial. The prosecution brought 0 genocidaires to testify that they committed a crime as a result of the broadcast by Nahimana on the radio. They didn't have any of those insiders. And then in the Šešelj trial, which is a Yugoslav tribunal trial, they did have those insiders, but they all dropped out during the course of the trial, or even worse, they recanted on the stand. So one of my argument here is that the best kind of evidence, so first of all, judges are looking for evidence of causation, mental causation, the planting of intentionality in the minds of the listener. The best evidence of that is the testimony of an insider. And thirdly, that testimony is very hard to get to the courtroom in the international tribunal setting, because these courts really don't have the structural capacity to protect witnesses and get them all the way through the trial without dropping out. Often the power of the perpetrators, especially in the countries, to intimidate them or their families is stronger. Also, here's another difficulty. In the incitement to genocide cases at the Yugoslav tribunal, so Akayesu being the first, but then also Ruggiero and Nahimana, they had evidence of only a couple of witnesses in the crowd. And the prosecutors were having to generalize about what the whole crowd thought as the result of the testimony of only a couple of witnesses. Obviously, the prosecutors can't bring the entire crowd of 200 people to the trial, so they have to bring a couple. But then the judges say, well, is this representative? Are these 2 or 3 individuals really representing what everyone thought they heard in the crowd? Because often the speech that is used is quite euphemistic, it's coded, it's not direct, it's not go out and kill all Tutsis. In the 400 transmissions of Radio Mil Colin in the Nahimana case, in those 400 transmissions, they only found 4 that were explicitly genocidal. The rest were statements like, Rwandans be strong, Rwandans do your duty, Rwandans face the invaders with nationalist spirit. Those are not clearly inciting to genocide statements. Now, they may be heard that way by the audience, but then you're in a difficult game of having to explain to the judges the local cultural and contextual meanings because the speech is coded. The speech is euphemistic. So that's a real difficulty here in these kinds of trials. So my advice for the prosecutors at the end of the book is charge inchoate crimes where you don't have to prove causation, and there are 2: incitement to genocide and hate speech, and limit to the examples where the criminal intent is clearly explicit in the Speech Act. I know this excludes a lot. This is frustrating because a lot of the worst kind of speech is euphemistic, but this law is still developing, and I think judges are still reticent to restrict freedom of expression, and so what they do is they really want to see the most egregious kinds of examples where the intentionality of the speaker to incite genocide is very clearly that in the Speech Acts, and that was the case with Julius Streicher. Julius Streicher said in Der Stürmer, the Jews of the East must be exterminated root and branch. That convinced the court. Hans Fritsch said terrible things about Jews, but he didn't say anything that explicitly genocidal, which is, I think, why they acquitted him. So let's, one of the pieces of advice is to go after only the worst kinds of speech acts where you don't have to do a lot of translation to the court. Disfavor those modes of liability which require direct causation. So instigation is one of the crimes. Instigating crimes against humanity is one of the crimes in the Rwanda Tribunal statute and the Yugoslav Tribunal statute. And I argue that these do require direct forms of causation, and these should be disfavored by prosecutors. Unless you have insiders that you really, really either have something on or trust and feel they're not going to drop out, and they're going to give you that evidence of mental causation. If the crime has already happened, then ordering, I think, is a mode of liability that makes sense. Because in ordering, you don't have to worry about causation. If a superior gives an order to a subordinate, then the causation is there in the order. The intentionality is in the order, and so is the effect on the listener. You don't have to worry about the explaining to the court what an audience in a political rally might have been thinking. An order is given down a chain of command, and the subordinate has to follow it. So there's clear mental causation in that context. And then I argue that actually we should be thinking about forms of speech that encourage others to commit international crimes as forms of complicity, as a form of aiding and abetting. Now, what's interesting about aiding and abetting is that it need not be causal, and it may actually even come after the fact. So statements that are condoning of violence may be considered aiding and abetting or complicity with violence. There's evidence in the US law of individuals who applauded someone who committed a violent act as being they were convicted of complicity. And I think we see this in the media trial at the Rwanda Tribunal. Those 4 explicitly genocidal statements by Nahimana and other broadcasters on the radio station, they all came towards the end of the genocide, after June 15th. You'll recall that the genocide starts on April 4th and it runs for 100 days. The most explicitly genocidal statements are actually after most of the genocide has occurred. And so how can they be causal? It's a problem, right? Well, if we think of them in terms of complicity and aiding and abetting, then they make more sense because they're encouraging of others. Okay, now I'm going to move to the US, and the rest of my talk, which I have to wrap up now in 10 minutes so we have time to talk, is going to focus on the US. So as I was finishing this book, you know, I was writing a book on incitement, and people would ask me at, you know, dinner parties or events I'd go to or barbecues, hey, what are you writing about? I'm writing about incitement. People would say, incite what? What is this? You know, what is this word? What are you doing that for? And yeah, I'm writing about propaganda, incitement, you know, incitement to genocide. And I never really thought it would become quite the issue in the US that it has since the 2016 election. Here's graffiti that was daubed on a wall in upstate New York on the evening of the election. And we've seen a dramatic increase in hate crimes since the 2016 election. A hate crime, I give the definition here from the FBI hate crimes website. It's interesting because it's a crime against property, person, or society that's motivated by race, ethnicity, ancestry, gender, gender identity, religion, disability, or sexual orientation. What does motivated mean? Well, in the standard federal definition, it means that the crime has occurred with hate speech accompanying it, or a hate symbol such as a swastika, or the police designated as such. So there are three different ways in which they can determine that a crime is motivated by bias. We saw an increase of 21% in hate crimes in 2016 against Muslims, a 20% increase in 2017, another big increase against Muslim populations. But we do know that hate crimes are drastically underreported in the United States. 87% of 18,000 police departments report zero hate crimes. So just to give you an idea, I live in Connecticut. Connecticut has a pretty decent reporting requirement. A number of police departments do a reasonable job of reporting, and they report about 110 hate crimes a year, which is more than Louisiana, Alabama, and Mississippi combined. Now, I don't feel like I'm living, so one hate crime is too many, but I don't know that I'm living in a state where hate crimes are, you know, running at 3 or 4 times the rate of some of these other states. I find it hard to believe that Mississippi and Alabama have fewer hate crimes. What we do have a problem with, I think, is reporting. And 15 states have passed legislation supporting the federal legislation to require reporting of hate crimes. Is there a connection, though, excuse me, between hate crimes and hate speech? Well, there's been some very interesting material from social scientists that has come out since the 2016 election. And you can see on the graph to the left, there are 7 years there of hate crimes reported. And you'll see 1 year doesn't look like the others. In the other years, the standard model is that hate crimes increase in the second quarter, basically over summer. For some reason, hate crimes are a summer phenomenon. And then they go down again in the third and fourth quarter. 2016 is different. Instead of going down in the final quarter, which is when the election is held, hate crimes actually continue to go up. And they estimate that there were approximately 10% more hate crimes overall in that year, in that particular quarter. And you'll see also on the right-hand graph the increase in hate crimes during the 2016 election, which is second only to September 11th for the spike in hate crimes. We can see a statistical regression analysis of the effect of Donald Trump's election on hate crimes. This does not mean that Donald Trump himself increased hate crimes, simply that there is a a correlation between his election and the increase in hate crimes. So there's no indication here of a causal relationship. There's simply a clear statistical correlation that social scientists are calling the Trump effect. But it begs a number of questions. There hasn't been a big increase in incitement and hate speech, application of true threat or intimidation or incitement law. And it begs the question, why is incitement law so seldom used to protect vulnerable populations in the US? Is there anything about our incitement laws that hinder their application? And I asked this question, can social research identify the likelihood that speech can elevate the chances of violence, which is some material that was in the end of my book, and you really need to speed up. If we look at incitement law, we started in the early 20th century with the bad tendency doctrine. So incitement is having the tendency to encourage disrespect for the law, not encourage violence, but simply disrespect for the law. So it was essentially a contempt of court kind of concept. We got the clear and present danger test after the First World War. And really, during the course of the 20th century, incitement law was used to go after socialists and communists. So Fox, if we start at the top, Fox, Schenck, Abrams, Debs, Gitlow, Whitney, Dennis, Yates, Noto, all of them socialists or communists. In Dennis, 3 guys are convicted of incitement to violence for sitting around reading the works of Marx, Engels, Lenin, and Stalin, and having a socialist discussion group. This is the 50s, the height of the Red Scare. And so what we see really is that incitement law is not about protecting minorities from the majority. It's about protecting the state from destruction or serious injury. And that's why our hate speech laws or our regulation of speech laws look so different from Europe. France and Germany and Austria and Belgium, they all rewrote their hate speech laws after the Second World War in the shadow of the Holocaust. And in the United States, our speech regulation laws actually go back to a time where the incitement law was about protecting the British Crown and then protecting the state, the republic after that. So that's one reason why our laws look so different. The main, the main case in the US that controls incitement law is Brandenburg, a 1969 case. This is held now for 50 years. Clarence Brandenburg, you see him here at a farm in Ohio burning a cross. He makes a statement about the suppression of the Caucasian race and revengeance. I didn't know that was a word, but he talks about taking revengeance against the government. And he's convicted of incitement and fined and sentenced to, well, he's not yet sentenced, but his range would have been 1 to 10 years in prison. Here is Brandenburg on the left at the point of his arrest, and the Supreme Court overturns his conviction. And they say that the state can't forbid speech unless that advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So there are 3 elements here. Advocacy, which is the intent requirement. They have to intend to produce imminent lawless action. That crime has to be imminent, it has to be likely. Well, we've seen, actually, you can see what happens in 1969. This is an engram, which is an analysis of how often incitement is used in newspapers and publications. You can see here the effect of Brandenburg is effectively to defang incitement law. That was a good thing at the time because the civil rights movement was in full swing in 1969. Incitement was being used a lot against civil rights activists. And what the state was saying, the Constitutional Court, our Supreme Court was saying, was the state doesn't need to be protected from, political dissent anymore. And so Brandenburg creates such a hard test that really is very difficult to convict anyone of incitement anymore. Let's look at advocacy. And I really have to wrap up here. I'm going to do that in the next 2 or 3 minutes. The advocacy requirement. Here, did anyone see these posters? They were actually on New York City buses for a little while. And it was a pro-Israeli group that was seeking to portray Muslims in a negative light. And they were on New York buses and in the subways for about 2 weeks. And a group of lawyers filed a suit against the organization that paid for this and said this is incitement to violence. And the court said no, that this is a mere advocacy of an opinion, and there's no incitement here. There's no advocacy of committing a crime. And so the Metropolitan Transit Authority then banned all political speech, which is why if you go on the New York subway now, there are poems instead of political ads. And I actually really like the poems because they're calming and they're usually very sweet. So, so that was a case, and advocacy cannot be content or viewpoint based. So that's RAV versus City of St. Paul. You can't just protect one group of people and not another, so that mitigates against any US municipal laws that just ban hate speech or Nazi swastikas or burning crosses. Imminence means more or less immediately. That's the case of Hess, which went to the Supreme Court, of an anti-Vietnam War protester who said, we'll take the street later. And likelihood, there's really not very much. In People versus Rubin, they tell us a few things about emotional appeals are likely to be given respectability when they appear in the media, that words that are uttered seriously are more likely to produce violence than those delivered in jest. But really, the likelihood prong of the Brandenburg 3-part test is very undeveloped. I'm going to skip over true threat. But here are my suggestions for states. I think that we can, so first of all, I don't think that US law needs to go the way of European hate speech laws. I don't think we have to become Germany and ban Holocaust denial or swastikas or incitement to hatred. We simply need to start enforcing the laws that we already have on the books. And I argue in a recent publication as well as in the book that we need a clear model which identifies the factors most likely to cause imminent lawless action. But right now, courts don't really have any idea of the kind of speech that elevates risk. And they decide this on the basis of hunches and personal biases, but they actually really don't know. So we need more guidance for courts from social scientists on what type of speech is most likely to lead to hate crimes. I argue also that we need to think about threat, and that true threat is a whole body of law that I haven't talked about, but that needs to be used in addition to incitement. And threat and intimidation may be a better path to go down than incitement law in defending minorities from hate crimes. And then thirdly, we need to get our data in order because we actually don't know what's going on. The Shepard-Byrd Act in 2009 reiterated the reporting requirement for hate crimes. A lot of states are reporting 0 hate crimes. Mississippi is one of them until 2017. And many of these states receive very large federal grants for all kinds of things. And one might want to connect those two things in the message that the federal government gives to states in their uniform crime reporting. 15 states have passed legislation reaffirming the federal reporting requirement. Okay, many of them are the usual suspects like California, Illinois, Connecticut, Massachusetts, but there have been a few states with white nationalist problems that have passed legislation. Idaho is one, and Maine is another. And they have really improved their reporting. And last year, the reporting did get slightly better. than in previous years. So it strikes me that we don't really know what the full extent of the relationship between hate speech and hate crimes is until we get decent data, and that's really one of the first steps that needs to be taken. So I'll stop there, and I'd be delighted to hear your comments or questions. Maybe Kim could help me in identifying those questions, but I'd be happy to respond to any remarks that you might have.
Richard, one quick question. What was the group again that was responsible for putting those posters on the buses? Did you hear me, Richard?
I heard the posters on the buses, but I didn't hear the first
which
part.
group was responsible for posting those?
Yeah,
Which group was responsible?
Right. Who was responsible for paying for the ads on the buses?
Yes.
Yes, it was the American Freedom Defense Association, American Freedom Defense Association, which was led by a journalist called Pam Geller, who writes for the New York Daily News. And if you're not aware, the New York Daily News is not what we would call a high quality newspaper.
Richard, we have another question that sorry to interrupt, Kim, that I wanted to just get some follow up on about the international legal framework for incitement as a crime. We understand that it's in the Genocide Convention, but what other information can you illuminate?
Yeah. So that's a really great question. So the Convention on Genocide, the UN Genocide Convention, is, as we know, called the Convention for the Prevention and Punishment of Genocide. However, the entire convention is oriented towards punishment, and there's only one piece of prevention, and that is the clause describing incitement to genocide. That's the only preventative function in the Genocide Convention. So that comes out in 1948, and then basically it lies fallow for the next pretty much 50 years until Akayesu. And that is the case at the first case at the International Criminal Tribunal for Rwanda. And Akayesu is convicted in, I think it's 97 or 98, one of those 2 years, for incitement to genocide. And really in between, nothing happens. It's not until that tribunal actually indicts Akayesu for inciting others in his municipality. He's a mayor. He incites others in Taba commune to commit acts of genocide against the local Tutsi population. And it's not until he's convicted that we have any case law on incitement to genocide. It's the longer name, proper name is direct and public incitement to genocide. So it's not until Akayesu that we learn what direct means. It's not until Akayesu that we learn what public means. And interestingly, in Akayesu, the Rwanda Tribunal says direct can be indirect if everyone knows what's being said. And so it does allow for coded and euphemistic speech. If a speaker like Akayesu is saying, Rwandans be patriotic, Rwandans be strong, and everyone in the audience knows that to mean a call to commit acts of violence against Tutsis and to commit genocide against them, then it may be understood in that way. So it's not really until those cases come out at the Rwanda Tribunal, and at this point, there's still the only convictions for incitement to genocide are at the Rwanda Tribunal. It's not until those cases come out that we actually learn what a court thinks direct and public incitement to genocide actually means.
So, Richard, my audio appears to be working better than Kim's. And so I am going to just read off a question we have from Mike Brand, who you may know because he's another Yukon person.
Hi, Mike.
He's here in DC. And he says, I realize that much of Richard's work is focused on the courts, but I'm curious if he has done any research, has any thoughts of targeted killings of those who incite violence or act as propagandists. The most famous case being the U.S. drone strike killing of Anwar I'm going to say it wrong, Awlaki, a U.S. citizen and al-Qaeda affiliated propagandist. That same strike also killed another U.S. citizen and propagandist, Samir Khan. Richard, your thoughts?
So I don't know a lot about those particular cases. I have done research primarily in the courts, it is true. I'm branching out now a little bit to look at cases of social media incitement to violence in Guatemala.
No.
I plan on going to Guatemala this summer to do field work on that topic. I've done some Skype interviews where I'm trying to ascertain the degree to which human rights defenders feel that there is a campaign undertaken against them by state-aligned actors in Guatemala, particularly the ex-military. And that campaign is on social media. And then there are a number of attacks against human rights defenders. 20 were actually killed last year in Guatemala, 8 in 1 month.
Oh.
And so I'm doing some non-court research on that topic. And look, it's very difficult to connect speech acts and social media campaigns with what is actually going on offline. So I'm trying to figure out how one might do that. We started with a regression analysis of the amount of hate speech online on social media. We followed 10 trolls in Guatemala who are mostly ex-military, and we coded their speech, and we coded their speech that was inciting a violence. And then we looked to see if there was any correlation with actual violent acts that were recorded, and we found there was no correlation. So it could be that our research model was bad, and we're going to do the research again. It could be also that looking for direct causation is the wrong theory. That hate speech and inciting speech simply doesn't work in that one-to-one kind of billiard ball causation model. That what speech does is have much more indirect effects. It may create a tolerance for violence. It may condone or encourage violence in a much more umbrella causation kind of way. If I respond to your direct question about Awlaki, I actually had the opportunity to ask Harold Koh, who was general counsel at the time to President Obama in the State Department, about that particular drone strike. And I asked him if the U.S. had a policy that propagandists were legitimate targets for extrajudicial killing, even if they were U.S. citizens. And so I was able to ask that question at a public gathering, and he responded quite defensively. His response was, Awlaki was not killed because he was a propagandist. He was killed because he was actually conspiring to undertake an attack against the United States. That was his response. I don't necessarily endorse his response, but I just want to convey to you the question and the answer.
Richard, I have a question for you about something you'd said earlier. You'd referenced that there was another recent publication where some of this work could be found. And recognizing that much of our audience is made up of teachers,
Yes.
Probably high school students, but also middle school students. Is there, so I know, and Kim has been reading your book thoroughly. I've been reading it as well. We're looking for ways to disseminate the core ideas in a way that teachers could use it in the classroom. And I'm wondering if you have any recommendations for other resources, other publications you put out where we could, that would have the potential to be used in the classroom?
Sure. Yeah, I've published some shorter pieces, which take elements of the argument in the book, which might be a little bit more digestible than reading the entire book. I also published an op-ed in the Guardian in December 2017, which summarized some of the main points at the end of the book, which are involve the identification of risk factors. And I'd be happy to point you towards some of those publications. One site I have where my work is freely available. It's on my SSRN site. So ssrn.com is the Social Science Research Network.
Okay.
ssrn.com, and if you type in my name, Richard Ashby Wilson, you'll see 18 publications that are up there, and they are either articles or chapters in books. One thing I would point you towards that's I think quite readable are the Hartford Guidelines on International Speech Crimes, which I wrote with a group of attorneys who work in the tribunals in The Hague. They work in the International Criminal Court and in the Tribunal for the former Yugoslavia.
Yeah.
And the Hartford Guidelines are written for attorneys, but the sections are smaller and they're written in hopefully clear and transparent language. We tried to make them as readable as we could. And that is it's a 150-page document, but there are sections. There's one on incitement to genocide. There's one on hate speech. There's a section on instigating crimes against humanity. And basically, we just summarize the cases that are relevant. And the cases are often an interesting way of teaching.
Yes, I would think, yeah.
I think if you give a student, a group of students, a short summary of a case, and ask them to read it and pull out what they feel to be the dominant themes, I think that could be a really interesting kind of teaching tool.
And I just want to reiterate that I know that a lot of the history teachers that are following right now are fully ready to read all of the book and dig deep into all of the background information. Mostly what I'm thinking about are places where teachers could pull sections for students to read with guidance from their teachers. And I think you've given us some great examples for that. And then Kim, you had a question from the Q&A section.
Yeah, and that can you guys hear me okay now?
Yes.
Okay, so before I answer that or ask that question, I wanted to, because it jumps off of yours, Kate, some of the people on the call are USHMM fellows, some are Pathways for Peace fellows, and have gone through Susan Bench.
I'm afraid you're breaking up a little bit, Kim. Could you start that again?
Yeah, so a lot of us are USHMM teacher fellows. Some of us are Pathways for Peace fellows, and we've gone through the dangerous speech training with Susan. And I'm wondering if you want to comment, Richard, on how your work and hers kind of complement.
So Kim, I'm going to suggest if you want to, if you would, can you type that and either text it to me or text it into the Q&A box, because we're not really, it's breaking up a little bit. I will read out the next question that's listed. Richard, this one's from Diana. Is there any evidence that making speech illegal creates unintended consequences? So, for example, making predatory groups pretending to be under the threat further victimized, or pushing them towards social media spaces like 4chan and so forth?
Yes. So great question. The answer has to be yes, that not all regulation of speech is a good thing. And I debated, so if you want to read a strongly pro-free speech book, there's one that just came out last year by Nadine Strossen, Strossen, and it's called Hate, what to do about it or how it can be met with counter speech. And Nadine was director of the ACLU, so it's the classic ACLU freedom of expression view. She doesn't want to regulate anything. She wants to meet it with counter speech and argument. And that's a very reasonable opinion. I debated her in New York last year at the Open Society Foundation, and it was a lot of fun. And one of the sections of her book is dedicated to some really embarrassing cases in Europe where individuals fall afoul or run afoul of the hate speech legislation in a particular country for speech acts that really we feel, most of us would feel ought to be allowed. Like they're offensive, they're horrible, but they probably ought not to be forbidden and repressed. And I'll just give you some examples. So a British woman is convicted of incitement for reading out a speech by Winston Churchill in the early 20th century, which says that Islam treats women poorly, and that the woman under Islam is subordinated. There is a Danish parliamentarian who is convicted and fined for saying that Islam wants to use democracy to destroy democracy. And that's not an opinion I agree with, but it strikes me that it's a political opinion which individuals in Denmark ought to be able to express in the public sphere. I would want to meet that kind of expression with counter speech. I'd want to argue with it rather than convict the person and ban the speech. So there are examples. Now, there are about 200 cases of individuals who are convicted of incitement to hatred in Germany every year. Actually more in France, about 200 to 300. And then there's a smattering in other countries like Denmark, Netherlands. Here's an interesting one. What do people think, and this is an open question to the group, about Geert Wilders in the Netherlands, who during the election campaign leads a crowd in shouting Moroccans out, out, out. And he is convicted of incitement to violence and fined.
So you're saying that, and I'm thinking that the Netherlands has one of the more liberal, if I'm not mistaken, approaches to free speech. Is that accurate?
It tends to be one of the more liberal regimes of allowing freedom of speech.
Okay. Kim had a question that wasn't coming through, so she's typed it, and I'm gonna read it out, Richard, if that's okay.
Yeah.
Many of us are United States Holocaust Memorial Museum fellows and Pathways for Peace fellows who have gone through Susan Benish's Dangerous Speech Project. Mm-hmm. How does your work and hers how do they complement each other, and are there glaring differences?
Yeah. I think Susan Benish is doing great work. And they have a campus speech project going now that I think is very valuable. There's, as people will be aware, a very lively debate right now on U.S. campuses regarding what to do about speakers like Milo Yiannopoulos and others who are clearly provocateurs. And some students want to protest, they want to heckle, they want to shut them down. And the debate has become very polarized. I think Berkeley, during its Free Speech Week, spent something like $5 million in security. This is a state university, which could be using $5 million for a lot of different things, including scholarships for underprivileged communities, and they're spending $5 million on the policing the Milo Yiannopoulos event and other events like it. So there's a reasonable question that can be asked about what are the limits of expression, how should faculty, students, and administrators deal with a whole range of speakers? And I think the Dangerous Speech Project have taken that issue on, and they've really tried to break down the different types of speech and articulate a model which says, okay, a lot of speech is offensive, it's derogatory, it's degrading, but we don't want to ban it. We want to meet it with counter speech. You want to ice of speech that is occurring in such a context that it's likely to lead to imminent violence. And that speech has to be dealt with differently. But I think the Dangerous Speech Project is making a very good effort to try and intervene in that debate. Excuse me. I don't know about any glaring differences between my approach and theirs. I would say if there are any differences, they're more at the freedom of expression end and dealing with speech with counter speech. And excuse me, I'm interested in applying the law where it's relevant.
I think we have time for one more question, if there is one from a participant. You can put it in the Q&A box or in the chat box. And Kim, you can type one in if you've got any last question that wasn't. I know you had some prepared. If you had one that you wanted to add in. I mean, I had things circled, but I'd prefer to hear from others who are listening and don't have a microphone. Okay, so in that case, I'm going to ask. So I'm wondering how much, and I think this is a broader question, not just about speech, but you'd mentioned.
So Kate, I see a question came up from.
Oh,
Kim.
good. Okay, great. Let's see that.
On the anniversary of Rwanda and Bosnia,
Okay,
what
perfect.
we still need to learn from this? Okay. What we need to learn is prevention. There's very little in the way of international mechanisms to prevent genocide. All the cases of incitement to genocide have been after the fact. They've been after the bodies are already in the ground. Incitement to genocide was meant to be used under the Genocide Convention preventatively. Mm-hmm. But courts are waiting until the genocide, the international community is waiting until the genocide happens before they indict anyone for inciting genocide. And I think that's missing out on one of the very few preventative measures that we have. If a political leader in a position of power and authority begins, as occurred in Rwanda, as occurred in Bosnia, to incite genocide openly, then the international community needs to consider whether an indictment from the ICC or some other body is warranted. And it may be overturned, but it could exercise a preventative function. It could actually warn the political leaders in a particular context not to use that kind of language.
So a number of folks that might view this as a recording are teachers internationally in areas that are recovering from the conflict, the very same conflicts that you've been discussing. Mm-hmm. I'm wondering if you have any insight in the role of educators and education in prevention.
Right. Well, it's hugely important. And, you know, genocides look very similar. They occur during wartime. They occur as a state is fragmenting. They occur when a leadership decides that the scapegoating of a minority is the way in which they're going to stay in power. There are a few scenarios, a small number of scenarios. And learning about that, learning about the Holocaust, learning about the Rwandan genocide in the genocide at Srebrenica and other genocides, is absolutely crucial in creating an informed citizenry that can anticipate situations, identify situations, and that is willing to act in situations that are spiraling towards genocide.
Richard, once again, we want to thank you for joining us this evening. I know that Kim is also sorry that her audio isn't working better, but I know she's been inspired by talking with you prior to the webinar this evening, and I know that the participants are all grateful for your time tonight and for your publications. Kim asks me to remind all of the participants that this has been recorded and that we will be sending it out tomorrow. Once again, thank you, Richard, very much for joining us this evening.
Thank you, and thanks for your questions. Good night, everybody.
Absolutely.
Thank you,
Good night.